Seamus, thank you. I want to start by congratulating FLAC on reaching middle-aged maturity. I have a long association going back to the early 1980s from my law centre days with both FLAC and the then Coolock Community Law Centre. And I want to start by paying tribute to the pioneers and indefatigable campaigners for social justice in both the early days and more contemporaneously. And I'm thinking of people like Jerry White, Peter Ward, Iseult O'Malley, the very much missed Dave Ellis, and more recently Saoirse Brady, Michael Farrell, Nolene Blackwell, and today Sinead Lucy, Paul Joyce, and many, many others. And of course, Catherine Hickey and Eilish Barry, who span both of those eras. And there are many more. And anniversaries are a time for both reflection as well as congratulations. FLAC has many achievements, including some key strategic litigation cases, developing independent community-based advice services, promoting pro bono support, recognising the value of developing policy and legal approaches to tackling social and economic injustice, and also highlighting the work of tribunals as well as courts. But somewhat depressingly, many of the issues that were around access to justice in the early 1980s in both parts of these islands remain pressing and sharply in focus today. Though the ways of tackling them are more wide-ranging than a generation ago, given technological and other developments. Nonetheless, strategic approaches to improving access to justice will require investment. It was mentioned this morning by the Chief Justice, and that must be focused on tackling unmet legal need where it's at its most acute. And this, for me, is about a holistic approach, and it's the one that sees technology as one part of the wider development of tools, and that recognises that funding of lawyers and legal representatives remains essential, but again is not the sole answer either. And a speaker at a recent conference in Britain on legal aid at 70 illustrated this by talking about the advice deserts in England and Wales for accessing legal services. And the speaker highlighted Ebbw Vale, which is in South Wales. And what she said was that there was no longer any legal aid lawyers in Ebbw Vale, no citizens advice centre, no law centre office, while the old magistrates' court in the town had been closed and now houses a food bank. Now, the developments and the context in England and Wales has been where severe cutbacks in scope and funding of legal aid through LASPO, a piece of legislation, became the catalyst for a vigorous renewal of pro bono and personal litigant support initiatives. And that work in England and Wales is very important and definitely worth looking at, but we need to find a way of avoiding a slash and burn approach as the way of driving reform. And that poses some challenges to us. It's against that backdrop that I want to then outline the recent research undertaken by the School of Law at Ulster University and by the Northern Ireland Human Rights Commission into litigants in person and barriers to legal participation. In Northern Ireland, we have around 5,000 people every year who go into court without legal representation, particularly so in the family courts, around private law proceedings, around custody, access, financial relief, domestic violence, and other issues. We have over 10 times that number who go to tribunals without any support. And we know from figures at tribunals that even bringing a friend or a family member doubles your chances of success. If you bring somebody, a lay advisor, then your chances of success double yet again. The research that we did had three strands. First, the researchers observed proceedings in the family courts and recorded those observations. Then around 180 personal litigants were interviewed, covering their circumstances as to why they were representing themselves, their experience, and they then completed a questionnaire on health and well-being and their level of participation in their own cases. Other key stakeholders were also interviewed, solicitors, barristers, family court judges, court service officials. The second strand then was looking at providing a legal procedural advice clinic to half of the participants to see if that made any difference. And that was conducted by the Commission, and those participants were again interviewed to ascertain their response to having some legal assistance. And third, the Commission undertook a human rights analysis as to the circumstances in which individuals are entitled to legal representation on human rights grounds in civil proceedings under Article 8 of the European Convention on Human Rights. The findings were a mixture of things that surprised and didn't surprise us. First of all, many personal litigants had actually surfed in and out of self-representation, so the idea that you either were never represented or always represented was not accurate. Often personal litigants were responding to rather than initiators of litigation, particularly in the family courts. And the main reason for going unrepresented, while it was cost, and interestingly not just the actual legal fees, but actually the uncertainty of knowing how much it would ultimately actually cost, and not being able to plan accordingly was a big barrier. And that says something about how the legal profession charges and sets out its charges. But many also chose to represent themselves for other reasons, due to dissatisfaction with their legal representation. And what the research found was that that dissatisfaction was based not on inadequate legal advice. The research found very little poor legal advice, but rather on poor customer care and a sense of a person not being a participant in their own cases. And that's an issue that, frankly, is not just down to personal litigants. It applies for those who are represented. And the examples are ones that will be familiar, frankly, to anybody who's been involved in the profession. It was issues, for example, of barristers who only become conversant with the case at the last minute, and as a result, people were clearly unnerved at meeting a barrister a week before their case, and the barrister appeared to know nothing about what the case was. The observation showed the barrister was on top of the case a week later, but that caused real difficulties for the individual for whom this was a very important issue. So people were making opportunity cost decisions on spending money. So, for example, keeping them, paying their bills and keeping their heads above water, keeping money for essential repairs, deciding they'd rather have a holiday than pay for legal services. Others, of course, didn't like the advice they were getting. It wasn't what they wanted to hear and chose to represent themselves, but that was a small minority. Personal litigants also expressed frustration at the lack of support and understanding they faced when they tried to navigate the system. In effect, the unrepresented litigant often felt that there was a code that lawyers and judges understood, which was inaccessible to them. It covered everything from procedures, etiquette, how you addressed a judge, the use of language. And interestingly, how a person felt that he or she was treated was almost as important in terms of the experience as the outcome that was actually achieved. So process mattered to personal litigants. On the converse side, many lawyers and some judges were also frustrated because cases took longer, personal litigants would express their frustration, sometimes unreasonably so, and lawyers and judges were left with the dilemma of whether to facilitate an unrepresented litigant when the lawyer's role was to represent their own client or the judge's role was to act as the adjudicator. Personal litigants then were often seen as troublesome at best and at worst vexatious. And moreover, myths prevailed among personal litigants, including, for example, that if a lawyer perfectly properly came to seek to agree facts or settle a case, then this was the lawyer being Machiavellian, because for the personal litigant, the assumption was that once you had lodged a claim, you inexorably were going to court. And the idea of settlement or negotiation beforehand was simply not something that they expected to happen. Now, there's a two-way communication gap between lawyers and personal litigants. And while the courts operate on the premise that both parties will be represented, and interestingly, the findings from research in England and Wales suggests that actually it's more educationally well-qualified and relatively middle-income individuals who fare even worse than those who have less education and less income. And that was because those people who were reasonably well educated thought they could surf their way through the system and they simply couldn't. The person who was floundering from day one, people recognised and at least facilitated. So slightly surprisingly, the more well-educated the personal litigant, the more the struggle became in practice. The procedural legal clinic, which was designed to help an individual navigate the process, was viewed largely as helpful, but too little too late. And the advice was not on substantive legal issues, and we think we need to look at how you deal with that, but on how to present a case, what written representations you should make in advance, what issues are relevant, expectations of the judges, things that help the person understand the code. The legal analysis based on Article 6 confirmed that there's no absolute right to legal representation in civil proceedings, though it may be required depending on a number of factors, including the importance of the issue at stake, the complexity of the case, and the ability of the individual to represent him or herself. And a key Article 6 case around legal representation is, of course, one that's close to home, namely Erie versus Ireland 1979, a very early example, frankly, of advice deserts in Ireland. But it's clear to us that there is not a one-bound, we're going to be free answer by way of comprehensive legal representation for everyone, either through human rights cases or public policy developments in either parts of this island in the near future. So in essence, the question comes down to, should the courts adapt to the needs of personal litigants or the other way around? To date, the latter approach has clearly prevailed. Personal litigants have a human right and, in my view, a common sense right to participate as effectively as possible in their own cases, whether legally represented or otherwise. We cannot turn personal litigants into lawyers, nor should we. Instead, we need to level the playing field as best we can, and the research recommendations reflect that, entailing cultural change for everyone, including personal litigants. So the recommendations embrace improved access to independent legal support, for example, through court-based clinics and other assistance, improved pro bono assistance, a recognition of the value of unbundled legal services. We still have in Northern Ireland, either you get a full legal service or none. Actually, what people often want is assistance partway through. And that's probably would make some legal services more affordable in certain circumstances. Better legal information on both court procedures and legal substance, training for lawyers on how to represent clients when personal litigants are on the other side, how to deal with those who are emotionally distressed, and judgecraft for judges in such cases. A charter of rights and responsibilities for all litigants and court actors, setting out the expectations and regulated through an independent complaints mechanism, and also the recognition of Mackenzie friends alongside ways of assessing their value through codified rules and other forms of regulation. The research was launched at a conference in which around half the participants were personal litigants. We had a certain trepidation in that, and at least one member of the audience was a man who had been jailed for contempt by the Lord Chief Justice for attempting a citizen's arrest of an appeal court judge in the Court of Appeal. Our main speaker was the Lord Chief Justice who had jailed the individual. So as you can imagine, there was a certain frisson as we began the conference. But interestingly, and important learning for us, in practice, the debates that day were very constructive and temperate. And what it reflected for me, and the lesson was, if you allow personal litigants the opportunity to participate meaningfully, then the response is actually a very positive one. So where are we now as I come towards the end of what I want to say? One outcome was to set up a personal litigants reference group and to make sure then that that group can feed its views into the recently created in Northern Ireland Shadow Family Justice Board and Shadow Civil Justice Council. The reference group has a solicitor, a barrister, a senior official from the Department of Justice, another one from the Court Service, a member of the research team from the UU School of Law, from the Human Rights Commission, a High Court judge, and an equal number of personal litigants, and an independent chair persuading a judge that He, in this case it's a he, should be sitting as a panel member and not chairing it was an interesting exercise. The independent chair has public, private and voluntary sector experience and has worked in pro bono projects. Interestingly, the personal litigants on this group reflect the variety of backgrounds that you find in personal litigants. We have the head of a social enterprise, a senior civil servant, a self-employed IT consultant who's now providing pro bono assistance to the court service on how to make its website more user-friendly, turning the traditional pro bono notion that only lawyers can do pro bono to do these things, and a woman whose first language is not English and who's currently unemployed. The first initiative of the reference group has been to scope what help is available and to conduct a walkthrough of the courts in Northern Ireland for members of the reference group to see how the arrangements can be improved with signage and other procedures. None of that costs, frankly, any money. We're now looking at issues of training that's available and how we can move that on. Future work will almost certainly embrace looking at information and advice needs for personal litigants and how a reference group can feed into the operational and policy developments. It's early days, and this is an attempt to bridge that communication gap that the research identified, and we'll see how it proceeds. So in conclusion, the research, its outcomes and its developments is just one piece, frankly, of a much wider jigsaw puzzle on how to tackle access to justice issues. For too long, legal and court reform in Northern Ireland, and I suspect elsewhere, has been driven by an inner circle. And that inner circle is both parts of the legal profession, it's civil servants, it's the judiciary, and it creates an unsurprisingly inward focus on the needs of lawyers, court officials, and judges. And what this research and its outcome, and the work I hope of the reference group will do, is illustrate why we need to adopt a consumer-focused approach in crafting solutions which meet the needs of applicants and respondents, lawyers and others, and recognises that process as well as outcome is important. And as in so many other forms, frankly, of public provision, puts users at the heart of the reform. And we'll see how that goes. So thank you very much.